Hello, everyone, and welcome to the second edition of CLEAPCon, an annual security conference organized by CLEAP Technologies. In this conference, we cover all novel topics and new subjects under the security domain. We founded this conference in the year 2021 to raise awareness about cybersecurity in the world. Since that time, we have been organizing various seminars, webinars, podcasts, conferences, and bringing together a lot of leaders from the industry, experts, government sectors, academics, and security researchers. So today, the final talk of our day one, we have Shubham with us. Thank you, Shubham, for joining us. Pooja, I would like you to introduce Shubham to our viewers.
Sure. Thank you, Shivani. So let's welcome our last speaker of the day, who holds a distinctive academic record, and he has presented papers in national and international seminars and contributed chapters in edited books. And he has written two books, of which his book Landlaws of Assam, a reference book for the students of Guwahati University. And he also edited two law books. And he's a young member of Singapore International Attribution Center. So that's Shubham Chatterjee. We are excited to have you here.
Well, thank you, Shivani and Pooja, for such a lovely introduction. I am really thrilled, amazed, and pleased to, be in the virtual platform of the CLEAPCon International Security Conference. I am esteemed. I'm deeply honored by your lovely introduction. So, yeah, this is the. You have said that this is the last speaker. I'm the last speaker of the day one. So yeah, I believe that all good happens in last. I believe I will be able to do justice to what I'll be speaking to. So I'll be sharing the screen once it's visible. Kindly please let me know because I'll be on the other side of the screen.
Yeah, we can see.
Yeah, is it visible?
Yes.
Okay. Okay. So, hello, one and all present here. I am Shubham Chatterjee. I am currently working as an in-house counsel for Pepsi Venture Builders. I am also simultaneously pursuing my master degree in criminal law from BREA University, Kolkata. And today I'll be speaking on the topic privacy, data protection, and cybersecurity laws in India. So the agenda for today's presentation, what I've kept is now to understand in the cracks that what is data protection and data privacy. I shall also be discussing a bit about right to privacy as a fundamental right. Then I shall be discussing on privacy policy and its elements. Coming to the data protection under GDPR, which is one of the fundamental law that regulates the cyberspace domain, then the data protection under Indian law, and I shall also be speaking a brief about the Personal Data Protection Bill 2019, which has recently been withdrawn by the Parliament. So now coming to the first slide, that is what is data protection and data privacy. So essentially data privacy is something, it has been defined as something who has the access to data. Ensuring this data privacy is a part of the larger topic of data governance, which ensures data integrity and trust. Now, what is data governance? Data governance is nothing but the systematic management of the data that are being collected, that are being used, gathered for various purposes. And data integrity and trust. When we as a user of internet do put up our data to some other source, putting up, we are putting a trust and confidence. We have trust and confidence upon those sites that we are putting the data. So data privacy, along with it, brings data integrity and trust. On the other hand, data protection is nothing but it provides a sort of tools and policies, the compliance regulations, which helps to ensure that the user's privacy requests are carried out by the companies, and companies are responsible to take measure to protect the private user data. Now, every data that are being collected, not only does the government collect the data, but there are so many private organizations today who are concerned with collection of data, gathering of data, usage of data. So data protection is essentially a set of rules and regulations that controls that tries to keep the maintain the sanctity of the data privacy. On the other hand, data privacy is something which is largely related to the data governance. The right to privacy is a fundamental right. We as a citizen of India are very much concerned with our fundamental rights. Part 3 of the Constitution of India guarantees us the fundamental right. So there are so many fundamental rights that are attributed to us, but then Article 21 of the Constitution of India is one such fundamental right, which is so largely been interpreted by the courts since 1950 that it is said that Article 21 forms the jurisprudence of the human rights. It is also said that if we scrap all the fundamental rights that have been entitled to the citizens of India, keeping only Article 21, it is itself sufficient to protect all the rights that are covered under Article 21 from Article 12 to Article 35 of the Constitution of India. Now, right to privacy is a fundamental right. The Aadhaar case, which is popularly known as Justice Case Putttaswamy versus Union of India. In this case, the Supreme Court has clearly held, the 9-bench judge of the Supreme Court has clearly held that right to privacy is one of the fundamental aspect of right to privacy is one of the fundamental aspect of right to life, and this is guaranteed under Article 21. Right to privacy cannot be segregated from Article 21. It is in 21st century. 21st century is a century of technology. In this era of technology, it is very essential that right to privacy must be granted the status of fundamental right, that also in explicit manner and not in implicit manner. Prior to this case, Putttaswamy case, there were two cases which came up before the Honorable Supreme Court. One is the case of MP Sharma versus Satish Chandra, while other was the case of Khanat Singh versus State of Uttar Pradesh. Both were the cases which were more or less related to the search and seizure. The prime subject matter was search and seizure, and the Supreme Court at that point of time took a narrower view and observed that right to privacy is not a fundamental right, but gradually with the passage of time, with the technology, taking over the manual things, now the Supreme Court has widened its view and it has expressly held that right to privacy is a fundamental right guaranteed to all the citizens as well as non-citizens who are residing within the territory of India to be recognized as a fundamental right. Coming to privacy policy and its elements. So what is privacy policy? A privacy policy is nothing, but it's a legal document. It discloses the way that a party is supposed to gather the data, to use the data, to disclose the data, and to manage the customer or client's data. Basically, in other words, it fulfills the legal requirements to protect the customer's or client's privacy. Now, when we go to the website of Amazon, Flipkart, we are so tech-oriented, we are so tech-savvy. Every other day, we go on to the online sites to buy the products. While buying the products at the end, or while signing up, there is something which pops up in our screen, that is, to click the checkbox where it says that I agree to all the terms and conditions that are given over there. So there's a lot of terms and conditions, a lot of things are written knowingly, unknowingly. Like nobody in 21st century, in today's day, nobody has the time to read all the things that are also written in so minute details. Nobody reads, and what we do, we all click the two check boxes. We tick the two check boxes, and we readily agree to everything that has been written over there. So when we read the terms and conditions, it also essentially includes the privacy policy within it. You search every website that has been available. You search every website, you will find the privacy policy given there. Be it a government organization, be it non-government organization, be it a school, company, startup, wherever you go, you see any website, you will find the privacy policy given there. Now, what are the elements of the privacy policy? The elements of privacy policy basically includes, number one, trust. Now, what do I mean by trust? Trust is something which creates a fiduciary relationship between the person who is providing the data and the person who is collecting the data. Like fiduciary relationship or the relationship which are based upon trust and confidence. You see the relationship of a doctor and a patient. A patient goes to the doctor merely why? Because the patient knows the doctor will be the best person to redress his problem. Similarly, you go to if you see the relationship between a teacher and a student goes to the teacher because the student knows the concerned teacher is expert in his or her domain. Similarly, when it comes to trust under the data protection, the the receiving party, the disclosing party who is giving the data, he has trust and confidence upon the receiving party who is collecting the data. So the main element of privacy policy is trust. Number two is consent. Without the consent, privacy policy cannot be taken into account. When you sign up for the first time in any website or any app, you give the consent to the app developers or the organizations to collect your data, to use your data, to disclose your data. Why they collect or gather or use or disclose your data? To do survey, to understand the consumer psychology, to understand consumer behavior. These are the prime reasons why data are being collected basically. Now, essentially, any organization, any website collecting the data must clearly write the purpose for which the information will be collected. It must be specifically mandated, written over there, that this is the so and so purpose for which the data is being collected. Now, coming to the disclosure of information, while on the other hand, it is very essential that data, privacy is a fundamental right. Privacy must be protected at any cost. Also, I will be discussing in later part. Also, there are certain, situations where information must have to be disclosed. You cannot say that once privacy will be infringed, so that's why we are not going to disclose the data. Nobody can do that. So that is covered under Information Technology Act, which I'll be, dealing at some point of time later. And then security practices. Essentially, people, organizations who are collecting the data, gathering the data, using the data, or disclosing the data must use tight security practices so that everyone's data is being protected. Every privacy in any cost, in any manner, privacy must not be infringed. Now, data protection under GDPR. Now, GDPR reads as General Data Protection Regulation. It is one of the revolutionary law that has been brought by the European Council Union, which has changed the entire set of entire domain of cyber law. It has set a new jurisprudence in the cyber law. Things have underwent rampant change. Topsy-turvy changes have been seen under the cyber law domain with the enactment of the GDPR. Now, GDPR is something which protects the personal data of the people as well as the European Union. So it is not that only the European Union collectively is, they protect their data, but it also somewhat protects the personal data of the people also at large. Now, as you can see, I've written that it takes the whole domain of privacy laws to next level. Data protection, after the enactment of the GDPR, has undergone significant changes, and today almost all the countries in the world are under the purview of GDPR. Almost all the countries of the world have used GDPR as a model law to frame their own law within their own territory or within their own state. So among so many of the articles which are being mentioned in GDPR discussing with our privacy, data protection, I have highlighted two specific articles which are very important under data protection under the GDPR. Number one is Article 17 of the GDPR, which provides right to erase. It means that the subjects have the right to erase the data having stored with any data controller or processor. Once we submit the data, usually in some of the websites, we are unable to erase the data. In that case, if you minutely read the terms and conditions, the privacy policy, we'll always find the organizations have one clause in that privacy policy that in case of any grievance, your grievance must be redressed. You can contact so and so person at so and so, email is given there. So if you are able to delete your data once you sign up to any particular website or app, it's well and good. If not, you can definitely contact the concerned person who is over there, who is managing other things, and you have the right to erase the data. So this is one of the revolutionary change that has been brought about in the through the GDPR. And second is Article 20 of the GDPR, which provides the right to portability. It means that under GDPR, the data subjects have the right to port their personal data concerning himself or themselves from one data controller or processor to another. So basically GDPR, when I speak about taking the privacy level to the next domain, next level under cybersecurity law, it starts from head till feet. Everything under the privacy law is covered under this GDPR. And India has also to some extent started, adapting the practices which are being taken up by the GDPR. It has enacted the Personal Data Protection Bill, which I'll be speaking in my slide. So coming to data protection under Indian laws, as far as India is concerned, there is still no exclusive law pertaining to the rights of an individual or their privacy. The only law which is applicable is the Information Technology Act 2000. Remember, right to privacy is something which has come up only in 2017, and still the government has not taken any concrete measures to include right to privacy as a fundamental right under Article 21. No such amendment has been made in the Constitution. Till now, it's the judgment of the Supreme Court which is applicable throughout the territory of India. But till now, the only law that is controlling the data protection is the Information Technology Act 2000. It deals with several cyber crimes and it provides the remedies against the violation of the act. Now, this Information Technology Act 2000, it relates to individuals' privacy. But remember, they are not exhaustive in nature. The scope of IT Act has been, the law has been framed in such a manner that scope has been given to insert any sort of information technology development that is consistently happening in the cybersecurity domain within the purview of the Information Technology Act 2000. So the major provisions of the Act dealing with the aspect of data protection are Section 43A, Section 72, Section 72, and Section 69 of the Information Technology Act. Now let us look at what is Section 43A of the IT Act 2000 speaks of. It speaks that the body corporate who is possessing, dealing, or handling any sensitive personal data or information of an individual and is negligent in implementing and maintaining reasonable security practices in protection of the data and results in wrongful loss or wrongful gain to any person, then such body corporate may be held liable to pay damages to the person affected. Now, basically, when the company is collecting any data, they are responsible to maintain the data. They are responsible to maintain with utmost trust, integrity. When the company or the institution fails to do so, and due to this website hacking or malware, the hackers, get a whole lot of data, individual data that are being collected. What happens? It results in wrongful gain to any person, a third person, a hacker who is not supposed to get my information. This has been disclosed. This has got leaked somewhere, and it has been, they are getting my data. So somewhere they are in a wrongful gain position. Number one. On the other hand, if I am losing, if due to security breach, if due to security breach of the organization, my data gets leaked, I am on the wrongful loss position, or the person whose data has been, been transferred to the third party, he is in the wrongful loss position. Now, whenever there is wrongful loss or wrongful gain, remember wrongful loss or wrongful gain is a crime as mandated under Indian Penal Code 1860. Whenever this wrongful loss or wrongful gain happens to any person, such body corporate may be held to be liable to pay damages to the persons who are affected. Now remember, Section 43A of the Act is such provision where no maximum limit is specified in the Act for compensation. If my data is leaked, if due to security breach, my data is in threat, I may sue the organization to claim as many amount as I think could compensate the loss that I have suffered. Every person whose data is being lost, he or she is in a position to claim as much amount. Think of a startup who due to lack of financial resources are not able to, maintain the data privacy, data security of the website. Somehow their data gets lost. And not about the startup, Big organizations like KFC, their Domino's, their data gets leaked. So what about the startup are, newbies who are just entering into the corporate world? They are just stepping their foothold in the corporate world, in the business world, to bring some revolutionary changes in the domain that they are working. Think of Domino's, think of KFC. They are not supposed to lose their data. They are some of the organizations which are being, fantasized, fantasized by the startups or every people who want to be in the business domain. They, use their set of models. KFC, Domino's, they happen to be the case study of the big business schools like Harvard, MIT, so and so, and their data gets leaked. So therefore, whenever my data or your data is being leaked and it is into the hand of any other third party who is not supposed to get that, you or I have the every right to claim as much amount of compensation that I think fit, that can compensate me for the loss that I have suffered. But remember, no monetary loss, no monetary compensation, no pecuniary compensation can ever give you the assurance that your data which has been lost will be in the safe hands. You are always on the risk position. That is very sure. Coming to section 72 of the 72A of the Information Technology Act, it ensures that the disclosure of information knowingly and intentionally without the consent of the person concerned and in breach of the lawful contract, it has also been made punishable with imprisonment for a term extending to 3 years and a fine extending to rupees 5 lakhs. Now, section 72A, on the other hand, while section 43A speaks about maintaining the data privacy and data protection of the body corporate, 72A basically covers not only body corporate, not organization, it includes individuals also. If an individual collects the data for any purpose that they are collecting the data, and somehow they make it known to the third party knowingly and intentionally without the consent of the person. Suppose I am doing a survey on a dissertation topic that I intend to put up in my dissertation. I have collected so many number of data. I'm working on say suppose HIV, or I'm working on AIDS, some sensitive topic where I'm not supposed to disclose who are the persons who have been affected by that sort of disease or not. And without taking their consent, I disclose the thing. I go on to disclose knowingly and intentionally. What I've done, I have breached a lawful contract. Contract is something which must not always be in writing. Contract can be made orally also. And in India, contracts made either orally or in writing are both enforceable in the courts of law. Yes, there is a challenge that when a contract is made orally, there are so many procedures that needs to be followed in order to prove that yes, the contract has been made orally. But when it comes to data protection and data privacy, even the oral contract itself forms a contract which is enforceable in the court of law. Tomorrow, if I go on to breach, knowing and intentionally breach the data that I have collected, I make it known to the third person. And for my breach of the data or my, leak of the data, that person is suffering from social dilemma, social stigma. What is happening? He or she is in mental stress. Who is the person responsible for causing his or her mental stress? I am the person responsible because I have leaked the data without his or her consent, which I'm not supposed to do. Now, when this kind of situation happens, we are liable, like people who commits a breach of this data, they are liable for punishment. You might face the days behind the bar for extending to 3 years, and also you need to pay the fine extending to the amount of rupees 5 lakh. That is what section 72A of the IT Act deals about. Now coming to section 72 of the IT Act, which deals with the penalty for breach of confidentiality and privacy. Now section 72 is another interesting section in the IT Act. It is not any specific provision relating to the breach of privacy by data processor, but it is about a circumstance. It speaks about a circumstance under which any person who in the pursuance of any of the powers conferred under the IT Act, rules or regulations made thereunder, because remember why I've written act, rules or regulations. Once an act is formed, sometimes, addendums are being made. So addendums are made in the forms of rules and regulations. Sometimes the act is not being amended. A separate set of rules or regulations are being published by the concerned ministry when passed by both the houses of the parliament, and it also forms a law annexed with the principal act. So any power which has been conferred under the IT Act rules or regulations made thereunder has secured access to any electronic record, book, register, correspondence, information, document, or other material without the consent of the person, or discloses such material to other person. Such person shall be punishable for an imprisonment, and the term for the imprisonment will be 2 years, or with fine which may extend to ₹1 lakh, or with both. So knowingly, unknowingly, what IT Act basically provides that whether knowingly or unknowingly, do not disclose any data. Respect everyone's privacy. Once you are getting the data, you are collecting the data, do not disclose it for only 2 cents of a profit. If you think that by disclosing the data, by selling the data, you would become very rich, it is very untrue. Now, in the era of technological domain, in this era of technology, you cannot expect that you will be, committing a crime and people will not be doing that. It would be a foolish act on yourself if you think like that, or might be you are in a very, in a very dark world. You must come out of that. So basically, the Information Technology Act provides that the crux of IT Act is do not disclose the data. If you disclose the data, get ready to face the consequences. That is the basic thing of the IT Act. Now comes the interesting part of the IT Act, Section 69 of the IT Act. So the IT Act says about so many things: protecting the data, maintaining data privacy, punishment. So many things are being put up. This Section 69 is an exception to all the provisions of the IT Act. It provides that when the government is satisfied that it is necessary for the interest of the sovereignty or integrity of India, for the defense of India, friendly relation with the foreign state, public order, or for preventing incitement to the commission of any cognizable offense, or for the investigation of the offense, the government can, for reasons recorded in writing by order, direct any agency or the appropriate government to intercept, monitor, or decrypt the data. Why? Data privacy, that I have told you during the first, while I was speaking in my first or second slide, that it is very true. Data must be protected, privacy must be respected. But when it's the question of the sovereignty and integrity of India, where it's the question of defense of India, where India is concerned with maintaining the foreign relations, a friendly relation with the foreign state. India itself is not sufficient. Even I'm not saying only of India, no country in the world is self-sufficient. Every country in the world is dependent on other country. So every country maintains a set of friendly relation with the other states. So when these factors are taken into account, when there is a need for public order, it is very true that data which are being collected by any organization, website, app, this must be disclosed to the government. And if the people who are concerned with the collection of the data, they refuse to coordinate with the government to assist the agency in conducting the investigation, they are liable to be imprisonment for a term not exceeding 7 years coupled with fine. So the government has the every right to call upon and analyze, review, monitor the data that has been collected. Because when the government feels that there is a need for the sovereignty of integrity of India, where the defense of India is concerned, it is very essential the government may ask for data, and every person concerned must cooperate with the government. So Section 69 of the Information Technology Act is essentially an exception to all the general laws or general clauses which are being mentioned under the Information Technology Act 2000. So coming to the Personal Data Protection Bill 2019, after the Information Technology Act 2000, this Personal Data Protection Bill 2019 is another step a step ahead that has been taken by the government of India to protect the data of the individuals concerned. So this idea of data protection bill was mooted in the year 2017, and the government of India appointed the Sai Krishna committee to prepare a draft of the personal data protection bill. This committee has done extensive research, studied all the laws concerning data protection all over the world, and then this committee submitted its report in 2019. This report, which has been submitted in 2019, came up for discussion before the Parliament in 2021. Now, this personal data protection bill, it sets the rules for how personal data should be processed and how people's right with respect to their personal information can be secured. This is the objective of the Personal Data Protection Bill 2019. It also proposed to create an independent Indian regulatory authority, which is able to carry out this law which will be known by the name of Data Protection Authority, DPA, to carry out the law, to give effect to the provisions of the law. Now, this bill, which has been presented for discussion in the Parliament, this bill has been withdrawn by the IT Minister just a month ago in the Parliament. Why? Because the Joint Parliamentary Committee suggested a whole set of new suggestive measures which have been given by the Joint Parliamentary Committee chairperson Meenakshi Lekhi, who has provided a set of new amendments that needs to be inserted in the PDP, and therefore the government has withdrawn this bill. Now it is very high time to see what the new personal data protection bill that will be presented before the Parliament comes up, because the 2019 protection bill says that the individual rights related to the data portability, access and correction, and objection to the processing would strengthen consumer transparency and individual choice. While every effort has been made under PDP Bill 2019 to strengthen consumer transparency and individual choice, at the same point of time, companies as well as institutions would have to also protect an individual's IP address, browsing activity, name, address, and financial details. It is very essential. So this personal data protection bill, when it comes up in new avatar that will be put up by the IT minister, I hope in the next couple of months, it will be very interesting to see what the new bill comes up before all of us. We can see that. So yeah, then that was all about my presentation on privacy, data protection, and cybersecurity laws in India. Yeah.
Thank you, Shubham. It was indeed an insightful session. As me also being from the compliance background and having all these standards, it refreshed the memory of the time when I was learning back then, and still we use it in our daily life. Though compliance becomes very monotonous, I would say, at a particular time, but yet very important and potent, and you I think fabulously kept across all the points over here. So I will just quickly check if we have any questions, and then we can wrap up our session. Okay, there's a question like, why and where is SEBI guideline used?
SEBI guideline, basically SEBI is concerned with the with security laws, with the security laws, in the sense I'm not speaking about the cyber security. SEBI is basically it's a regulator of the financial institution. So SEBI basically is concerned with the company's financial details, financial aspects of the thing. So as far as the privacy laws, data protection laws is concerned, with my limited knowledge and resources, I believe that SEBI is not the competent authority in this jurisdiction. So Yeah, the one who has asked the question is for you. Like, it is the Information Technology Ministry, the Department of the Information Technology. They are concerned with the data protection field, and as of now, we don't have any, dedicated regulatory authority as so far as the cyber security or the data protection laws are concerned in India. I hope this answers your question.
Yeah. If it doesn't, then you can connect with Shubham on his LinkedIn profile and you can continue the conversation forward. And with that, thank you, Shubham, for taking time out and speaking at CleapCon. And you have a good night. Thank you so much.
Thank you so much, ma'am. It was indeed my pleasure to present the topic on this forum. It was my pleasure indeed. Thank you, everyone.